Today's training is really special because we have our expert, Julia Weber, who's an attorney with also a master's in social work degree. So if you think about those two degrees, you wonder like, how's that possible? Aren't they kind of antithesis? But she somehow manages to be that attorney with the compassion and trauma-informed approaches. So I always appreciate Julia. And also she's really like national expert on this topic of firearms and domestic violence and how they intersect. So I'm really honored to have her in our community to train us. And this training is part of our Contra Costa County domestic violence firearms. What is the actual full name? Here, what is the actual full name of our thing? Gun Violence Prevention Task Force. I'm sorry, there are just so many different task forces, but this is really an important task force, Gun Violence Prevention Task Force, because what we want to try to do is to prevent domestic violence and other types of family violence. So with that, I give you Julia.
Well, thank you, Susan, and thank you everyone for taking the time to join us today. Hopefully, this will be in support of your important work. That's my goal. And I appreciate the generous introduction, Susan, as well. I know we have so many experts here on this call, in this training, and if only I could interact with all of you, which I do hope to do over the period of time I'm involved with this project, to learn more about your important work and how it relates to what we're covering today. Um, what what I want to do, what we've discussed doing as part of this training, is to provide context for the important work of the task force. And by that, I mean ensuring that we have a good foundation to make the task force's work as successful as possible. And I know we have a couple of hours set for this training, which is a lot of time. I understand if people need to step away, come back. I believe we're recording this as well. But my hope is you'll be able to focus. I know it's hard with Zoom. I also know it's a very difficult topic. We who do this work often come to it with our own personal experiences of violence, and of course have the stories of people we've worked with who have perpetrated harm or have experienced harm themselves. So it's a lot. We're talking about what my colleague Ari Freilich, who's the head of the Office of Gun Violence Prevention under the Attorney General here in California, he talks about this work as murder prevention, which is heavy but true. So I have enormous respect for everyone taking the time today, especially given the seriousness, the somber nature of the topic, and how important it is that we all approach it with a trauma-informed lens. By the end of it, my hope is that you will have a deeper understanding of the legal context, and also an even greater investment in what you can do. And I firmly believe this, what we all can do to prevent firearms violence. There are steps we can take. It feels overwhelming. It's a lot. And I have seen enormous success around the state. I've had the honor of working nationally on these topics and heavily in California. And things are changing. We're making a difference. The laws that we've passed in California are evidence-based examples of how lives can be saved and injuries can be prevented. And you're all a part of that. So thank you. Also wanting to put this project in context for you, there are a number of different firearms relinquishment or firearms violence prevention programs that are funded. This isn't all of them, but I wanted to just demonstrate by county. I also do work with the judicial branch, and the courts in California are being asked to step up and participate in a number of these efforts. And this map generally focuses on where court procedures are implicated. So we have violence prevention programs that have very little to do with the court, of course, and programs that have little to do with law enforcement. But this shows some of the projects that have been funded either in the same way that the Contra Costa Task Force has been funded, or uh, in other ways. So the Judicial Council, the policy-making body for the state court system, received funding to support courts implementing firearms relinquishment policies and procedures. And so you'll see that there with the darker, the sort of turquoisey. I need to learn the word for each of these colors. But this map just shows that we have programs that are funded through the CFCC stands for the Center for Families, Children, and the Courts. And that's the $40 million that went from the state budget. So we have courts in the goldenrod color that are being funded to implement DVRO, domestic violence restraining order, and GVRO and criminal firearms relinquishment programs. And we have a couple of places, San Diego and San Mateo, that have received local funding or funding from the state just to work on a pilot project. Then we see that we have a number of task forces. Santa Clara County has had a task force working on firearms relinquishment for some time. San Diego has recently started one. Los Angeles is in the process, and of course, Contra Costa has established yours as well. So this is part of a bigger picture where firearms relinquishment has become a top priority for government funding and for legislative policy. You're not alone. You're doing important work. We can learn from each other, and let's get into it. So the legal landscape. If you are hearing about this from a lot of different sources, you shouldn't be surprised. I'm not surprised. Governor Newsom signed 25 pieces of legislation into law this fall related to firearms violence prevention. Many of them addressing firearms relinquishment or turning in firearms, complying with the firearm prohibitions. We have had prohibitions in California in the domestic violence context since the 1990s, actually predating the federal prohibition. So in our civil restraining orders for domestic violence, we said you can't have firearms, you can't have ammunition for a long time. And then slowly we built up additional civil restraining orders that include prohibitions and criminal protective orders that include prohibitions. This makes us unique in the country. No one has the breadth and depth of firearm and ammunition prohibitions that we have in the restraining order context. So it lends itself to a lot of preventative opportunities. Unfortunately, what we've learned over the last 20 plus years, 30 plus years now, is that a lot of those laws have not been fully implemented. And so what you see in this legislative context is an increasing number of what we call belt and suspender laws, or we really mean it. We're not kidding. We really mean that we want to save lives. We really mean that you need to ensure someone who may be a danger to themselves or others is separated from their firearms for some period of time. Maybe not permanently, but that we actually implement the law, not just tell people they are prohibited. So here are a number of the laws. Some of them are more significant than others. I'd say if you're a child custody mediator or evaluator, or you run a program with folks who may be engaged in that kind of work, child custody matters, effective January 1st of this year, you're required to have training on the risks associated with access to firearms in child custody, contested child custody cases. Um, if you're working with folks who are in pretrial diversion situations, mental health diversion, and military or veteran diversion under penal code section. And I'll be throwing out a lot of penal code sections and family code sections. And if you have questions, jot them down. Happy to, we'll make sure you have the slides. We'll make sure you get any citations. There are handouts um, that I'm hopeful maybe Natalie or Susan, you can put that link to the handouts in at some point in the chat, or I'll do it at the end as well. So the legislative list will be in those handouts. The Penal Code sections 1001.36 for mental health diversion and 1001.80 for military diversion. Prosecutors can now request that someone be separated from their firearms and ammunition while they're going through diversion. So that's under AB 455, for example. So a couple of different things going on here. Public institutions, secondary, post-secondary institutions, colleges, universities can now request school violence prevention orders effective January 1st of next year. So delayed implementation there. There have been significant changes in the works and in place now to try to make the law enforcement exemption for firearms in domestic violence, criminal, and civil cases clearer. So there are circumstances under which someone who might otherwise be prohibited from having firearms and ammunition can request and be granted an exemption for a firearm that they need for work under certain circumstances. And for peace officers, that is a mandatory psychological evaluation. For people who are not employed in law enforcement, it's also a discretionary psychological evaluation. And again, it's limited for a specific firearm. And there's a whole process to go through, but it's been confusing. So that's AB 2759, where there's been some changes made and some additional fixes in the coming year. We also saw the January 1st of this year, AB 2907, Zabur's bill that imposes relinquishment requirements. The prohibition's been there for a while, but what is the process to ensure compliance in domestic violence criminal conviction matters? And that went into effect January 1st, so of this year. So there's some overlap with the most significant change, which is SB 899 that I'll be talking about today, which goes into effect next year. So keeping track of what the law is at any given time, not easy. One of the other more significant and lesser known changes happened here on number 18, AB 3083, where courts are now hearing both domestic violence restraining order matters and gun violence restraining order matters are now required, regardless of whether they have the resources, to get what's called the 6306 check, or the Family Code Section 6306 check, which is a list of databases. One of those databases is the Automated Firearms System, or AFS, which I'll be referencing quite a bit today. The Automated Firearms System, again, is a unique characteristic in California. We have a database where you're expected to, if you legally own firearms, register your firearms. And checking that allows a court issuing a firearm prohibiting DVRO, and they all are unless you have that exemption, or a gun violence restraining order, to check and see, oh, the subject of this restraining order owns X number of firearms. Those currently owned firearms need to be relinquished within 24 hours if they were not already turned over to law enforcement when the order was served. So we'll get into that a little bit, but this is the first time that has been mandated They overcame a restriction before that said it's only mandated if you have the resources. Now they've said all courts, effective January 1st of this year, need to be running that check. The benefit of that is that law enforcement serving these orders should have information on the paperwork indicating that the person has X number of firearms that are registered. There should also be information about any unregistered or illegally owned firearms that may have been revealed as part of the evidentiary process. Uh, it's also beneficial because the court then can be very clear about their role in reviewing the case to ensure that within 48 hours, there's proof of relinquishment in the file. So this again provides a little bit of a legislative context for you. This list will, like I said, be in your handouts and provides a bit more context. So no need to look at it now, but you'll have that. And again, happy to answer questions. Not only did we have 25 new firearms violence prevention bills signed by the governor, we also are existing in the last few years in a context in which there have been a number of other firearms violence prevention bills. There's a process for defendants not in custody to relinquish firearms, and reports to DOJ that are required under AB 732. I won't be spending time on that today, but if there are questions, happy to talk with anyone about that after the training. AB 818 went into effect last year, and law enforcement agencies are required to serve domestic violence orders after hearing whether or not they're at the scene upon request. So you may have the sheriff primarily serving your DVROs, but if a petitioner walks into any law enforcement agency and says, I want this order served under this new change, that agency is expected to serve the order. So there's a heavy emphasis on service right now. SB 599, it deals with the intersection of child custody and domestic violence and the expectation that we take refusal to comply with these prohibitions seriously and restrict visitation or custody until such time as someone complies or is identified as not needing that restriction because they're no longer dangerous. Dealers are required to store up to 40 firearms for any reason in California. So this is an area in which either voluntary separation from firearms benefits from the availability of storage, or in a situation where someone chooses to relinquish to a dealer instead of law enforcement, dealers should be taking those firearms. And there's a resource I encourage you to take a look at, gunstoragemap.com. Again, gunstoragemap.com identifies dealers around the country who have said they will take firearms into storage for any reason. And then SB 320. SB 320 was a change from 2022 that set out very specific firearms relinquishment procedures in civil domestic violence restraining order matters. And it puts obligations on law enforcement, the courts, and procedures that involve recognizing that when someone becomes prohibited, when a firearm is or firearms are part of the case and someone becomes prohibited in the civil domestic violence matter, it's critical that there be very quick follow-up to ensure compliance. So I'm going to be emphasizing a lot about SB 320 today, and then its partner piece of legislation, which is SB 899. And SB 899 takes the provisions in SB 320 and applies them across all civil restraining orders. So civil harassment, workplace violence prevention, elder abuse, and school violence prevention orders, and gun violence restraining orders, as well as criminal protective orders, and make sure that all of those are consistent in how they approach both expectations on the courts for providing information and reviewing the case, and on the individual who becomes prohibited, and on law enforcement. All of those folks are covered in those policies. So again, just an overview of that, and then we'll be talking in more detail about those various obligations. So why is this important? Again, I find inspiration and sort of guidance in understanding what my role is as a professional in the work I do, by understanding the consequences of and the benefits. Why do we do this work? Most firearm owners, we assume, are responsible. Most firearm owners, the research shows, consistently support common sense.
I think it's free. For the most part.
Thank God. See, Brian, thank you. Support common sense restrictions on access to firearms. There's a lot of support. All of the gun violence prevention national advocacy organizations have come up with the same results in doing polling and focus groups, that generally people, the majority of firearm owners and people generally support the idea that when someone is perpetrating domestic violence, they should be restricted in terms of accessing their firearms. When someone is having a crisis where they may be threatening to harm themselves or others, it's a good idea to ensure that they are separated from their firearms to reduce the risk of suicide and homicide. So we know that there's been a significant increase in firearm ownership in the last few years, especially a spike during the pandemic lockdown period. Generally, people own firearms, they say, for self-protection. That's the most predominant reason. Also for hunting, it's part of their family culture. There are all sorts of reasons why, but firearm ownership crosses race, class, geography, red state, blue state, purple jurisdiction. For those who don't own firearms and didn't grow up in or live in a culture in which firearms were prevalent, it's important to recognize how many people own firearms and to avoid making assumptions, because firearms violence is a major public health crisis, and recognizing that this kind of violence is more likely to be perpetrated when there's easy access to firearms puts us in a better position to have what I think of as a public health conversation with anyone we're working with, just as we would about the need for sunblock or to toddler proof your home. Most people have electrical outlets. Those need to be appropriately covered. You don't want them pulling down furniture. Most people have furniture. So the more we understand that firearms are likely to be in a significant number of homes with the folks we're working with, and the why behind ownership, we're in a much better position when there is a crisis to talk about those risks and to help reduce those risks. And what are the risks? So in domestic violence situations, when firearms are present, we see a significant uptick in lethal outcomes. It makes it 5 times more likely that a victim of domestic violence will be killed, regardless of who owns the firearm. So the industry has spent some time encouraging victim survivors to purchase firearms to defend themselves, but the research shows that that increases their risk. And it's not just lethal outcomes. We're looking at serious injury. Over 1 million women have been shot or shot at by an intimate partner. The majority of homicides, domestic violence homicides, are perpetrated using a firearm. We've seen an uptick. It's now the number one leading cause of death for pregnant or recently pregnant women is being killed by an intimate partner, and firearms are the predominant weapon of choice. So that intersection of domestic violence and firearms, particularly lethal, and it's why we have so much robust policy in California designed to reduce that risk. I'll also note that the U.S. Supreme Court last year in U.S. versus Rahimi upheld as constitutional the restriction on firearms in civil domestic violence cases in a case called U.S. versus Rahimi. And it was a remarkable case because it was an 8-1 decision. So we don't get a lot of 8-1 decisions with this Supreme Court. But everyone except Justice Thomas upheld the notion that because of how long historically we've been regulating dangerousness in this country since the beginning of the foundation of this country, Congress and other legislatures have the ability to restrict access to firearms, to put that burden on the Second Amendment when someone is a danger to others. And domestic violence is that dangerous. So we now have support for the constitutionality of these prohibitions. Unfortunately, tragically, we know there have been too many children who have been harmed, shot, injured, killed at school. Gets a lot of attention. What doesn't get as much attention is the fact that if a child dies in a mass shooting or is injured in a mass shooting, it's much more likely that that shooting happened at home with someone they know than it is that it happens at school. So this Stanford study is one of the few studies, and it's just come out recently. We've had a sense of this for some time. First of all, the majority of mass shootings have some connection to domestic violence. On top of that, those mass shootings tend to be the most lethal. And then the third important point here is that children are much more likely to die in a mass shooting at home than school. And you can see here, I've shown now two different graphs, the relationship here between the child and the shooter on that bar, the sort of tan brownish bar there on the left shows that the relationship is apparent. It's the same kind of graph on the right. So it's telling the same story, just in different formats, showing that the parent or an acquaintance or neighbor, someone who has some connection, you see this family members, if you lump them together, parent, aunt, uncle, sibling, former relative or in-law, grandparent or cousin on that bar there. Deeply concerning. And the media does not cover this as effectively. And so while it's awful that any one child is shot and killed at school, there's a lot of effort that's going into reducing those risks and to addressing school safety. We've got to put that same kind of effort into addressing the risks associated with domestic violence and being at home with firearms and relatives who may be in crisis. So this just came out last week and is getting quite a bit of attention. We also know that this is an area that we have to be concerned about because of risks to our law enforcement community. So these are numbers from 2023. The 2024 numbers just came out. And, tragically in 2024, 342 officers were shot in the line of duty. 2023 was 378. But 50 officers died as a result, according to the National Fraternal Order of Police that puts out this report every year. So the number of officers shot went down 9% since 2023, but the number of officers who were killed actually went up 8%. So we've got to pay attention to the seriousness of this. Again, the prevalence of firearm ownership and the risks associated with that. We also know in California, we have yet another unique component. So we have the broadest number, the highest number, and the broadest and deepest levels of restrictions addressing firearms violence. We also have the AFS, the Automated Firearms System, and then we have the Armed Prohibited Person System, or APPS. So APPS is really a couple of things. First, APPS every day pings as a computer system that AFS database, and then it pings the prohibited persons list. So people who have become prohibited because of a domestic violence restraining order or a criminal protective order or a conviction. And it spits out a list of folks by county. This all happens in Sacramento, that show that how many people are prohibited and currently own firearms. That's the APPS list. So you can be prohibited, but if you didn't have firearms, you won't be on the APPS list. You'll just be on the prohibited list. And you can own firearms. If you don't become prohibited, you won't be on the APPS list. You'll just be listed in the automated firearm system list. The other component here is that there's a team in Sacramento, the APPS team. And every day they can handle approximately 2 to 3 cases. There's 23 to 24,000 people in the APPS database at any given time. It went down a bit last year, and in their legislative report, the Department of Justice, the State Department of Justice, said they believe that has to do with greater enforcement of these relinquishment procedures and policies, especially under SB 320. So the belief is it makes a difference. We know that APPS team often works at the local level with local law enforcement when somebody has not complied with the requirements. But, APPS is also one of those things that's, again, Ari often talks about this, is the goalie on the soccer field. You got to have the goalie, but if you're already down there with the goalie defending the goal, things haven't happened further upstream, upfield, that could have prevented that situation from occurring. So APPS steps in when a person has not relinquished after that 24 hours, provided proof to the court within another 24 hours. Can do a tremendous job. But again, in the legislative report, they consistently have said that what needs to happen is enforcement, oversight at the local level. And APPS usually is very happy to work with local law enforcement to support efforts. So they'll do training, they'll team up on big cases. So your community has already had occasion to work with APPS, as this story indicates here, in Richmond. And this was done as an effort that dealt with this individual ended up having a lot of high capacity magazine. I think they had this was from January of 2024. There were 11 military style machine guns, 133 handguns, 37 rifles, 60 assault rifles, 7 shotguns, 20 silencers, and a lot of ammunition. And this was someone who had become prohibited. So again, by the time it got to APPS, we're talking about a period of time in which this person maintained access to their firearms. We want to support these efforts and also support efforts that are designed to get the firearms earlier. The Department of Justice's Office of Gun Violence Prevention, I've mentioned a few times, really leads in this area, and they have put out a number of reports, one of which has focused on looking at gun homicide rates by county and population size. So certainly, more populous counties tend to have higher numbers of gun homicides overall. We see this especially being true in Los Angeles County, which is about 25% of California's total population, and they've suffered 32% of all gun homicides in the period of time that the office has looked at this issue from 2016 to 2021. But if you look at it at a per capita basis, some counties, certainly in the Central Valley and Central Coast region, have a much higher gun homicide rate. So for example, Kern County is has the highest rate here. It's not a huge county, but they have 9.1 homicides per 100,000. That's the highest in the state and more than double California's statewide average. So you can see there Contra Costa sort of about a third of the way in or so. These data I think are important to just keep track of and to know about, because the kinds of efforts that we're engaging in here are designed to reduce this kind of outcome. And you'll see the Office of Gun Violence Prevention's report really emphasizes this idea. California used to be known as the murder capital in the 90s. In the mid-90s, there was a mass shooting in San Francisco known as the 101 California shooting that happened at a law firm. I knew somebody who was killed there, a fantastic attorney, 18-month-old son, who happened to be there doing a deposition. And the law community, the legal community, organized around that tragedy and established the Law Center to Prevent Gun Violence, which has worked since the 90s to change policies in California and at the federal level. And what this report from the DOJ describes is the trajectory, the change in California from having an incredibly high rate of homicide statewide to one of the lowest in the country. And I've just pulled out these quotes that the number of lives, over 140,000 lives would have been saved if the rest of the country had the same laws as California. And if we didn't have those laws, around 19,000 or more people would have been killed. So looking at hard numbers, we can tell the story that policy and procedures makes a huge difference. And I'll just reinforce that specifically in the domestic violence context, we see a 16% reduction in firearm-related homicide when we separate people who are prohibited from their firearms. And we see a reduction in gun suicide as well when we separate people in crisis from their firearms. So how do we go about doing this? Since we know it works, what do we have to do? And that's where this sort of relinquishment approach and our main focus for the rest of the training is, which is we have a variety of tools in our toolboxes. Some of you are deeply involved with the legal framework, implementation of key policies. Federal and state laws can help shape our approach. We have arrest, prosecution, incarceration, in some instances, criminal protective orders in other instances. We have civil restraining orders, mental health prohibitions. That's sort of the legal context. But we also know gun violence prevention can't be done only relying on any of those approaches. We know that those approaches involve a certain kind of power and control that may be necessary to promote safety. But we also know that ensuring greater economic support, access to childcare, giving people a chance to voluntarily separate from their firearms during a crisis, engaging in safety planning. There are a number of things that we can do that can help reduce risk without only relying on the criminal or civil legal system. Today, we're going to be focusing on policy, legal policy, but I want you to leave this training thinking that's the only way to go. There are cases that warrant other kinds of interventions. So in your materials, you will see that you have, I don't know why the document showing up twice there, but you will have one version of this document in your materials, which is the Department of Justice every year, sometimes a few times a year if the law changes, puts out a list of the various ways people can become prohibited. And you'll have the copy from last year in those handouts that I referenced. So that's a good reference just to have an understanding of it. We also know that for those of you who are in law enforcement, It's important to recognize the role of what is often thought of as proactive policing. And this comes from various training manuals and training programs focusing on what we can do around firearms violence prevention. And the work we're talking about here really, I think, is highlighted with the problem solving and person focused approaches. Because there's so much there's a variety of ways that firearms violence is perpetrated. What we're talking about here is a kind of firearms violence that can be prevented if we focus on individuals who have been identified as particularly dangerous. And those are folks who are perpetrating domestic violence, have been convicted of domestic violence, or who are otherwise in some kind of crisis. And we're trying to get to the sort of underlying behavior as well. So it's part of an approach that should be part and parcel of the work we do. Sometimes when we talk about firearms violence prevention and relinquishment, we'll hear a lot of references to overtime or we can't do this without additional funding. And I'm very sympathetic to the need to properly fund all of our public institutions to save lives. At the same time, the message that I hope to get across is this is just part of how courts, law enforcement, service providers, probation, and other entities need to do our job in the 21st century. Firearm ownership is prevalent. This is what we need to know about in order to do our jobs most effectively. And we have the policy framework to do that. So I've made reference to the various firearm prohibitions in restraining orders. And that's really what we're going to emphasize today is what is the relinquishment requirement? What is the role that various entities are expected to play, including the courts, law enforcement, individuals in these cases, probation to some extent. Firearm prohibitions show up and are well described in another one of the Department of Justice's Office of Gun Violence Prevention reports, which is, again, we'll have one of the handouts in your materials on this. In all of these orders, firearms and ammunition are prohibited. There may be some differences with tribal orders. Out-of-state orders might be different. With out-of-state orders, you may have to look at the federal prohibitions. But for all the California state orders, firearms and ammunition are prohibited. We also know that under certain situations, certain convictions, and mental health situations as of July 1st for diversion as well, people become prohibited. So what does that actually mean? Well, when people are looking at the different orders, they are guided by our Judicial Council self-help website or local self-help agencies, in addition to some of you who I know provide these services to folks in the community. And they're going to need to get a sense of what's the right tool for the particular situation. So, for example, when we talk about firearms and restraining orders, you'll often hear about the gun violence restraining order. The gun violence restraining order is an order that specifically prohibits current ownership of firearms and ammunition, prevents someone from being able to purchase through a dealer firearms and ammunition, but it contains no other remedies. So it doesn't restrict someone from going to a particular place, from contacting a particular individual. It's the only order where there's no named protected party. It is designed largely to address risks where someone is in danger of harming themselves, so suicide prevention, or has a generalized mass shooting kind of threat, not for a particular location and not for a particular individual or a household, for example. So the GVRO, by its very nature, we could expect we're not going to see a ton of those because people who are threatening harm are often abusing or threatening a workplace or a family member or a neighbor. in which case you'd want not just the GVRO, you'd want a bunch of other remedies. And what we often say these days is that all of our other remedies include a GVRO plus. So a domestic violence restraining order includes a firearm and ammunition prohibition and protects an individual named in the order, restricts access to a home, a workplace, and so forth, and a whole bunch of other remedies. Civil harassment for people who are not in a domestic violence relationship. Again, firearm and ammunition prohibiting, elder abuse, when there's physical violence, firearm and ammunition prohibiting. All of these have the same requirements. And that means that when an officer serves these orders, that is, the order's been granted, either the temporary order has been granted or the order after hearing has been granted, and law enforcement serves the order, they are required to remove any firearms in plain sight or obtained through a consensual search. And they're required to say, you are now prohibited, turn over your firearms to me. The law is written so that it says they're required to ask, but if they don't ask, the person has 24 hours. So you're required to ask, but just as another sort of protection, you have 24 hours to turn in your firearms and another 24 hours to provide proof. So all of this should be happening within a 48-hour period, the relinquishment process. Turn those firearms into a dealer or to law enforcement. So there's no difference in terms of policy with respect to the firearms prohibitions. You see this in the handout that's in your materials from this report. It breaks down by case type how these tools are different and where they're similar. So again, you get the firearm and ammunition prohibition, you have the requirement to relinquish, and that requirement is on both law enforcement to ask the question, remove the firearms, and it's on the prohibited person. So this is without an investigation. This is at the time of prohibition. Okay. So I really suggest relying on that document and taking a look to understand the consistency in the policy framework, as well as the differences depending on the relationship or the type of violence we're talking about. And to get into this a little bit more, we can see that you have emergency protective orders. So just starting at, let's say, law enforcement being called to the scene of a situation. Law enforcement are the only people who can request emergency protective orders. That's done by contacting the court, the on-call duty officer, the judicial officer or magistrate. And law enforcement has a couple of choices. They may be effectuating an arrest. They may believe that someone needs protection. And if they do, the emergency protective order, EPO 001, as the form is called, is an appropriate response. You need to be able to assert to the judicial officer that there's reasonable ground finding that the person is immediately and presently dangerous in terms of abuse, child abduction, or stalking. And one of the things we think is important to point out for those of us who are doing this training and this kind of work with folks is that even if there's an arrest, it still may be appropriate to seek that EPO because you don't know when that person's going to come out. The nature of this EPO is that it lasts 5 to 7 days. And that's because there's heavy emphasis on a protected party being able to decide if they want to move forward with any kind of longer term protection. Because in most cases, the EPO 001, you're dealing with some kind of a relationship. And people may be co-parenting, they may be reliant on the other person for economic support. They may be fearful that obtaining any kind of longer term order might be harmful to them instead of increasing their safety. But this effort to allow for some short-term emergency protection is critical. And at the scene, the penal code requires, again, that any firearms are removed that are in plain sight, firearms and ammunition, and that may be obtained through a consensual search. So this is a very important moment where firearms could be removed, the person becomes prohibited. Some of those firearms they're not going to get back if they're not legally owned firearms. Even when the EPO expires in 5 to 7 days, they're not getting those firearms back. They may be looking at a longer term prohibition because the protected party pursues a longer term domestic violence restraining order. They might be prohibited already because of a conviction, or they might be, if they're arrested, arraigned, and a criminal protective order would be issued, which again is firearms and ammunition prohibiting. So this moment, when an EPO is requested, is a fantastic moment to begin that critical relinquishment process. And those duties are already baked into the law. So it's just part and parcel. It's not an extra thing. It has been required for a long time. And then the EPO 002 came into being, and that's the Gun Violence Restraining Order EPO. Similar kind of expectation. Law enforcement, this is a longer order, 30 days, because law enforcement becomes the petitioner in this case and would need to show up in court to address a longer term gun violence restraining order. So unlike the DVPA, the 001, that doesn't set a hearing. 002 sets up a hearing to determine if the subject should be prohibited for 1 to 5 years after this initial EPO. This is to prevent suicide, like I said, and generalized mass shooting threats. 97% of the orders after hearing in GVROs have been sought and obtained by law enforcement. So most of these cases start at the EPO stage and then prohibit people for a longer time if law enforcement pursues the order after hearing. If they don't show up at the court proceeding, then the order goes away. And this is a very similar framework to the DVRO proceedings. Same kind of expectation, remove firearms in plain sight. If a family member obtained a GVRO and you're serving that order, removing the firearms, requesting them at the time of service is expected, required. And if law enforcement doesn't serve the order or doesn't make the request, that person has 24 hours to turn in their firearms and another 24 hours to turn in a receipt to the court showing that they've complied. What SB 320 and now SB 899 will do is require that the court take a look in the file to determine whether or not the person has complied. And if the person hasn't complied, they're required then to report non-compliance to the prosecutor and to law enforcement. They're also required at the front end, the court is, to provide local information on how to comply. And the good news here is that combination of providing information on how to comply with follow-up by the courts and law enforcement, we're seeing a huge uptick in compliance. So that's, again, without an investigation, without what's referred to often as the knock and talk, without the APS team coming in or a SWAT team or a more extensive intervention, which may sometimes be necessary. But some number of folks are complying with the prohibitions when we put these other kinds of procedures in place. So how do we get there? Main components of implementing this policy are as follows. Key actors have to have critical information. So that means the court needs to know, does this person own firearms? Are they threatening to purchase firearms? Do they have access to someone else's firearms because they're living with someone else who is a legitimate firearm owner, but they're threatening to do harm? So we're going to have to figure that out. We have to make sure that the legal remedies are actually available. What by that I mean that if you go to court, you get good information about how to obtain these orders, that law enforcement knows about all the tools that law enforcement has in its toolkit, that service providers know about safety planning and giving people options that are meaningful. Because if you're going to go ahead and try to get one of these orders and there's no follow-up when there's a violation, it's unlikely you're going to see this as a genuine remedy. Then we have to make sure orders are served effectively. We need to make sure orders are understood. Do people know what's required of them and how to comply? That's that information provision. We have to ensure that if there's not compliance with these firearm prohibitions, there is something that happens, not just in a GVRO, for example, not just a violation of the CPO that results in an arrest or a probation violation, but also in any of these case types. You can't have, if I walk in through this door and I'm prohibited, I can expect consequences, but if I manage to walk in through this other door, nothing's going to happen. We need consistency around noncompliance. And then we got to get these orders into the databases because we have too many tragedies where much of this was done. The person was still able to walk into a dealer and purchase a firearm because the order never got entered. So I want to draw your attention to Penal Code Section 18250, which I've mentioned a few times, but not specifically by name. That's the penal code section that says when you're coming up on a scene of domestic violence, where there's any kind of threat to human life or a physical assault, or when you're serving an order, domestic violence restraining order or a gun violence restraining order, taking temporary custody of a firearm or any other deadly weapon, actually, in plain sight or through a consensual search is required. So that's that initial piece, but then the courts are going to step in and do things like make available this kind of information. So Contra Costa has this form, how to turn in firearms and ammunition. This is the kind of local information we want to make sure anyone who becomes prohibited is given. So to the extent you're involved with any of this process and procedure, you want to make sure this information form is part of your work. If you're listed on this information form, make sure it's accurate. And make sure that if someone were to call that number and say, hey, I want to turn in my firearms, that whoever answers the phone knows how to take that call, because that's really critical. And I haven't heard this in Contra Costa County, but we do have reports of people attempting to turn in their firearms and being turned away because of concerns about storage or someone's lack of familiarity with this. We don't want prohibited people going forum shopping and trying to find somewhere to comply and then eventually giving up. Take the firearms and then determine the best way to store them. And that's not to minimize storage concerns. One of the things the task force is working on is ensuring that there is adequate storage. Given how many firearms some individuals own, this is a real challenge, and the state is paying attention and trying to seek remedies around that. And if there are questions about destruction and retention, that's a whole other training we can get into. But just recognize that people may be showing up or calling, and law enforcement is expected to respond accordingly, and dealers as well. Okay, so what happens? Some of this may sound redundant, but we want to make sure that there's an understanding of what's expected and allow time for questions or comments on this as well, now or in the future. So you're showing up under 18250, you know that those you're going to remove the firearms in plain sight or through a consensual search. Under Family Code Section 6389, when those orders are being served, the domestic violence orders, law enforcement must request immediate surrender of firearms and ammunition. And if it's not requested, or someone says, well, those firearms that you have listed there that I'm registered as owning are in my cabin in Tahoe, then what's emphasized is you have 24 hours to turn them in and another 24 hours to turn in the receipt. That receipt is supposed to be turned in not only to the court, but also to law enforcement. So you may have some experience with that or not. We don't believe that many people are turning in a receipt to law enforcement. The review process really happens at the court. That's the most critical. And then, as I mentioned, Family Code Section 6306 should be run either by the sheriff or the bailiff. Someone in the court process is running that check. And that information on the automated firearm system is then provided to the court in DVRO and GVRO cases. We don't yet have that requirement in civil harassment or any of the other orders, although the criminal protective order, the criminal judge should have that AFS information from the prosecutor at the time of arraignment, during the proceeding, or post-conviction or at conviction. Courts have to provide local information on how to comply. That's what you got that form for in Contra Costa. Under 6383, for a DVPA action, a domestic violence restraining order, law enforcement must serve that order upon request. And then the court must review the file for compliance or non-compliance. When we talk about how will we know that the task force is successful, or how do we know how Contra Costa is doing?
Let me turn it down.
Oh, no problem. I'll let you go.
Yep.
These are the components that you want to be looking for, right? All right, so what happens when there's non-compliance? And this is where we might get into some of these investigations, some more significant time or burden on law enforcement and the courts. Under Family Code Section 6322.5, the family court, and then this is going to apply again January 1st next year, so the civil courts as well. You're going to have to make findings in the DV action about whether or not this person owns firearm and has complied. When they find non-compliance, the court must immediately report that non-compliance to law enforcement, the relevant law enforcement agency. So the courts in Contra Costa County should be doing that. This was effective January 1st, 2022. Then law enforcement must take all actions necessary, the law says, to obtain firearms and ammunition. So that's been the law since 2022. Once you get that report of non-compliance, all actions necessary to obtain firearms and ammunition. Within 2 business days, the court is also supposed to be notifying the prosecuting agency. Now, what does the prosecuting agency do about this? This could be a violation under Penal Code Section 29825, as well as any other criminal charges that may go along with the behavior that engendered the domestic violence or associated with violating the restraining order. The family court also needs to consider the DV violation and very soon with any kind of restraining order violation, whether custody and visitation should be impacted. So visitation might be suspended or denied, or supervised. Virtual visitation might be considered. It's also a determination to consider in the rebuttable presumption decision about whether joint or sole legal or physical custody can be awarded to the person who's been prohibited. And the court can issue contempt and monetary sanction orders as well. So there are some things that are supposed to be happening. And with respect to non-compliance, you're going to see a couple of forms that are involved here. And the DV 820, you may see this form in if you get a report of non-compliance, you may see the 830, which is directly provided to the agencies, prosecutors, and law enforcement. It should have the information about what firearms are involved from the AFS check or from any other evidence that the court heard, for example, from declaration. So this would be designed to elevate the sense of risk for anyone involved with the case, as well as for the protected parties. These forms are going to be duplicated in the gun violence restraining order context, civil harassment. So you'll see non-compliance forms in the coming year for all of these case types. Now, switching gears a little bit just to do a parallel with criminal procedures, AB 2907 went to effect January 1st, and that specifically addresses criminal domestic violence cases and sets forth requirements for handling those cases. So when you have a situation where you have an arresting officer in a domestic violence case, and it's specifically defined under Penal Code Section 273.76, the officer must query the automated firearm system through CLETS, through the California Law Enforcement Telecommunication System, to determine if there are any firearms owned or possessed by the person who's been arrested. Law enforcement, again, as of January 1st, must also ask the person being arrested, the victim, any other household members, about any firearms that are owned or possessed by the person being arrested. And then law enforcement must ensure, again, that under 8250, those firearms are removed. Anything that's discovered through a consensual search needs to be removed and taken into custody. The documentation for this arrest has to be provided in detail, including any actions related to removing those firearms. And that AFS report has to be given to the district attorney or the prosecuting attorney who's handling the case. So we already see this SB 320 in the civil context, SB 899 coming up with respect to criminal protective orders and all the other civil orders. And then we already, as of this year, have this kind of expectation in criminal domestic violence cases. That going back to those components, getting the information and then following through by providing this information to the court. In these cases, Rule 4.700 kicks in, and the court is required to have a compliance hearing to ensure, if the person has not yet complied, that they will comply. But at this point, any firearms that were available should have been removed, and any follow-up that's supposed to happen would largely come through the court, through the prosecutor, and then subsequently with law enforcement. In all of these matters, both the civil and the criminal non-compliance, the other remedy in response to non-compliance is possible search warrant being issued. Penal Code Section 1524 allows for the issuance of a search warrant if we're talking about a situation involving domestic violence, if the firearm is the result of a mental health issue, that's in 10-1524. And then if it's a domestic violence situation, or we're talking about a gun violence restraining order situation and the person hasn't relinquished. So there's a strong basis in the search warrant provisions to say we know this person has firearms. We have reason to believe they have firearms. They have become prohibited. They're refusing to relinquish. Time for a search warrant. Under AB 2621, the law enforcement has for some time been required to have protocols for handling gun violence restraining orders, but it's been updated. So it's a wonderful opportunity to, number one, check and see if you have protocols. My sense is that lots of folks do, but not everyone knows about them. They might be in a manual somewhere, or on a computer somewhere. They may be prominently posted, and you may already be familiar with what your agency expects. But they need to be updated now. No longer does the law indicate that a GVRO is appropriate in a domestic violence situation. It doesn't mean it's not appropriate. It's just not considered to be one of the foundational components when thinking about getting a GVRO, in part because there's no protected party. So a GVRO may not provide enough protection, unlike a DVRO. In order to pursue that gun violence restraining order, officers do have to present evidence, or their attorneys have to present evidence that would allow the court to issue that order after hearing. And those firearms need to be stored, and the protocols can address that as well. So you're also expected as a law enforcement agency, for those of you coming with that background, to have protocols for handling domestic violence cases. So a great opportunity to just take a look and say, how are we handling this? So another way to be looking at these issues is to be taking a glance at endinggv.org. This is relevant for domestic violence service providers in particular, those of you who are working directly with clients in this area. You want to be taking a close look at what kind of remedy is the most effective. Is it one that includes protecting parties? Then it might be a domestic violence restraining order. Are we looking at suicide reduction? It might be a gun violence restraining order. Ending GV walks through the various tools and how to go about obtaining the appropriate remedy for the situation. This was developed with Cal OES funds and led by the California Partnership to End Domestic Violence. And I hope it's a useful resource to people. I recommend it often. And it goes through these relinquishment procedures as I've been describing them. And I think my main point here is that there's no difference. So sometimes I'll hear, well, in a gun violence restraining order, it's easier to get the firearms. It shouldn't be. Gun violence restraining orders, domestic violence restraining orders, civil harassment orders, and all of the orders have the same requirement. You serve the orders, you ask for the firearms, you take the firearms, you store the firearms. If they're not done if it's not handled that way, the person has 24 hours to turn in the firearms and another 24 hours to provide the receipt. And how do you know you're successful around this relinquishment process? So first, we want to make sure the court has a local protocol for handling these cases. How does the court get that 6306 information? How does it review the files? Is the court holding a review hearing? And that's the criminal court or the civil court. I believe Contra Costa is holding compliance review hearings in domestic violence restraining order matters, but we're in the process of trying to document exactly how your process works. So if folks on this call or this training have information about it, we can discuss that. How are violations being reported? And how do we know that judges and clerks understand this significant policy shift? So that's one big component, is what is the role of the courts and how are they handling implementation in this area? Another one is the court providing local information on how to comply? I'm going to give you an example. Orange County, so when SB 320 was being debated and proposed back in 2021, an investigative journalist, a reporter for Cal Matters named Robert Lewis, took a look at Orange County and their files, and he ended up looking at a relatively small number of cases, but 25 cases where domestic violence restraining order cases, where there had been evidence provided that the person owned firearms. So in all 25 cases, they owned firearms. The court acknowledged that. It was part of the proceeding. In all 25 cases, the person became prohibited. And in only one of the cases was there what's called the DV 800. So when I keep talking about the receipt that has to be in the file, you'll see there's a DV 800, there's a GV 800, a CH 800. Those are all receipts that need to be filed within that 24 hours after they've relinquished their firearms, 48 hours after they've been served. And only one of the cases had a DV 800 showing compliance. None of them had been reviewed. There was no follow-up. So that's 24 other cases where that person is in the armed prohibited person system, maybe for some follow-up a year or two later, maybe not, maybe they fall through the cracks. And an individual went through that process of seeking a restraining order, getting the restraining order, describing firearm ownership, and still the court did not follow up. So that story lent a lot of support to the adoption of SB 320. Now, fast forward to today, Orange County is one of those courts. The Superior Court benefited from that $40 million that we allocated from the state budget to support relinquishment. They worked together with law enforcement in Anaheim to do significant training. But more importantly, in terms of front-end prevention, they had judges say, we take this seriously. You are prohibited. We expect you to comply. And I'm going to be reviewing the file and holding a review hearing. And they've seen a huge uptick in compliance. Over 800 firearms relinquished during the grant period without significant law enforcement intervention, without significant use of overtime. And then that allows the resources for those hopefully fewer cases where people persist in non-compliance to get the benefit of more significant law enforcement involvement. So you have a form. So let's check that off. Although it's also worth considering, how do people get that information? Is it consistently provided in any firearm prohibiting situation? But we know at this point there's at least some information available locally on how people in Contra Costa can comply. And we have that evidence from the Orange County example that makes a difference. Another way of measuring success is whether the community can say consistently that law enforcement serving these orders. I'd also say arriving at the scene. Are they asking about and obtaining firearms and ammunition? So the scene of the situation or at service, whether it ends up resulting in an arrest or an emergency protective order, that firearms are being considered at each point in this process. And, service is critical, not only, again, in domestic violence cases, it's required under the law, but across case types. So we want to know if this is happening, another indicator of success. And it's part of what the task force is funded to work on. And again, baked into the law, this requirement's been around for a long time. It's part and parcel of the everyday work. And the funding is really designed to promote protocol development, training, and again, where we can find some dollars to investigate what hopefully will be a few number of non-compliant cases, then we want to make sure and get resources to the right folks to do that. So do we see those DV800s in the file? And I'd say within the next year, we want to see the GV800s for the gun violence orders, the civil harassment orders, all the relevant orders. And are those receipts being included in packets? There's an associated information form, the DV800 info, the GV800 info, civil harassment, CH 800 info. Those are all there as well, and they provide good information from a statewide perspective. So what that local information form does is take that statewide information and makes it directly relevant to the local jurisdiction. And then those armed prohibited person system numbers. So another way of measuring success is that 23 to 24,000 number that I mentioned in the armed prohibited person system. Every month, a report is provided to law enforcement with a list of the folks in the county, the numbers, and law enforcement can access the confidential information directly. Who in the county is in the armed prohibited person system. So I actually don't know whether there's 1,000 people, 500 people, 10 people in Contra Costa County who are in apps. But it's a really good way to be measuring your impact, because you might have an uptick as we see more prohibitions and we know firearm ownership is prevalent. But if we can get those firearms within that time frame, support the person being compliant within that time frame, then you're likely to see a decrease over a period of time, or at least a recognition that you're doing a more effective job at supporting compliance early in the process. Which, of course, for those of you who are working in the criminal defense world or in probation, the courts, service providers, for everyone, we want to reduce unnecessary exposure to the criminal legal system. When we delay, it not only puts communities at risk, it also creates unnecessary contact and the possibility of future arrest. So Mr. Rahimi, for example, he was the individual in that U.S. Supreme Court case. He became prohibited through a domestic violence restraining order in Texas, made him prohibited. There was no effort to support any kind of relinquishment procedure, so he never gave up his firearms. Subsequently went around Arlington, Texas, shooting up the town, committing various violations by shooting up a Whataburger restaurant, shooting when his friend's credit card was declined, shooting at a car accident scene, shooting at a government official's car. He's eventually arrested for all of this and actually prosecuted by the feds in violation of a number of different provisions. But one of the charges was having firearms under federal law in violation of the civil restraining order. And that's what he appealed his conviction based on, saying he had Second Amendment right to have his firearms because that was a civil procedure. And as I stated, that was his conviction was eventually upheld after initially being overturned by the Fifth Circuit. It was upheld at the Supreme Court, and the provision prohibiting him from having firearms was found to be constitutional. But if he would have been in apps, but they don't have apps in Texas. We have apps here, and we don't want Mr. Rahimi's to go around committing those acts, he eventually, Mr. Rahimi, wrote a letter from prison and said, I get what I did. I'll never have firearms again. I only had them to protect my family, which I always find interesting, given that he was perpetrating harm against his family. But this is a man whose life has been, challenged now by his ongoing interaction and use of his firearms that he should have been separated from a long time ago. So the community was impacted. A number of people put at risk, and that woman and his child that they shared, who initially sought that protection, was extremely vulnerable. We don't want to have those kinds of situations. So who's getting those numbers in apps, and what kinds of efforts are being undertaken to reduce the number in apps or reduce the time between the prohibition and separation from the firearms compliance? I sometimes will hear from communities that, we do a good job with gun violence restraining orders, or at the time of an arrest, getting the firearms, but we have less consistency in domestic violence civil restraining orders, for example. So another way of measuring success is, what is it going to require to ensure that there's more consistency, that people are supported in complying as close to the time of prohibition as possible across case types. So we want to see that in civil and criminal as we're beginning to measure success. And then again, referencing the courts, are violations taken seriously with respect to the implications for child custody and visitation, given how extraordinarily risky those cases are, especially for protected parties or victims of domestic violence and their children. Referencing back to that, mass shootings that happen in the home are particularly dangerous. Having a place or several places where victims can go when they see the prohibited person on social media with a firearm, or they hear through family members or friends that the person has firearms in violation of the restraining order, can they contact the DA? Can they contact law enforcement and expect some kind of follow-up? What is the process for handling non-compliance after the fact, or as part of the case, as the case develops in civil and criminal, is really critical. And then our service providers providing information, engaging in safety planning, and ensuring that people are relinquishing all of the things that we're supposed to relinquish. I haven't mentioned body armor, for example. People are prohibited from having body armor in many instances, and certainly precursor parts or unserialized firearms, ghost guns. Is there a level of understanding of how to have those conversations? For example, the same way it's not that effective to say, are you a victim of domestic violence, and expect someone to feel like you're building rapport, you're able to say, I'm going to talk with you a bit more as a service provider about your safety. And part of that involves talking about access to firearms. And I'm doing that to raise awareness about risk and also to help reduce that risk. We have a number of examples of scripts and ways of approaching that. So thinking about measuring success, this is all really the main components. And this will be, of course, in your materials when we get that to you. Your thoughts about what you know, what you need to know for your job, really critical. And we have a few more things to go over, but at this point in the training, as you've listened to me for a lot of time, is to ask you to please go to this link, which I don't know if that can be provided in the chat by someone, or the best way to make that happen, but I'll check the chat, see if it's there. And we'd like you to take some time to to answer these questions, please. And so we're going to pause for a bit. Suzanne, Natalie, I leave it up to you how long you'd like to give folks, but we'd like you to please answer these questions. It's critical for our grant, for the resources coming into Contra Costa. So please, if you would, click on that link that Suzanne has put in the chat and go ahead and answer the questions. And let us know if you have any trouble accessing the questions. I think we'll start now. Right, Suzanne? Does that work?
Yes, so the link should work. I was able to do it, and I see the form that popped up on my computer. Please let us know if you cannot access it. It is really important that you let us know what you know, what you want to know, what you have learned. So this is pretty straightforward, very few questions, about 5, I want to say. And let's say about 5 minutes, and we're going to check back in.
Thank you.
Julie, I just took down your slides for a minute so that we could just have some background music while we're waiting for folks to fill out the form.
The most important thing is family. AAA share.
So let's see. One more minute.
And while we're waiting, we actually have a question in the chat, Julia. Do you
Wait,
mind
wait, wait. We're gonna have question and answers a little later. Let's finish
Okay.
that first.
Yeah, I can tell we have 25 responses. So far, we have 51 participants. So let's see if we can get a few more responses before we move on to the questions in the last part of the training. Thank you all for taking the time.
Julia, 25 is pretty good.
Yes, I commend the group on their attention and commitment. It's awesome.
Yeah, because
And,
sometimes if you send out the evaluation form after training, you get back, I don't know, sometimes 15-20% return rate.
Yeah, you know, we have 26, so it's inching forward. No.
How about one more minute? How many, Julia?
I think we're up to 28 now, so great job.
Okay, well, for those of you who haven't had a chance to fill it out, the link is still open, so please feel free. But I do want us to finish the presentation and also an opportunity to ask questions. Is that okay, Julia?
Absolutely, yeah. So let me just pull this back up, and hopefully you can see that. And yeah, you got the slides?
Yes, we're good.
Okay, great. So just I'll answer the question in the chat, and then give you a couple minutes to ask any other questions. Maybe put those in the chat if they're coming up for you. Here are some of the obstacles that you might be encountering. The biggest one we've seen around the state is just inconsistent approaches. I think I've emphasized that heavily. We don't want people to just be experts on gun violence restraining orders, for example, or only experts on domestic violence restraining orders. There's a lot of tools in the toolkit. And for those of you working in direct service or interfacing with the public, having familiarity with all the different options is really critical. Storage, there's a lot of work being done on how long things need to be stored, firearms, ammunition, body armor, when things can be destroyed, and the inadequacy of current storage provision. So we'll be working on that. Service, again, heavily emphasized. Understanding dangerousness, often after an incident, we want to know what kind of red flag there was. Domestic violence is a big red flag. Those with mental health diagnoses are more likely to be victims of violence. Suicide is the majority of firearms violence that results in a lethal outcome are suicides. So we want to be thinking about ways to reduce suicide and harm to self. When you hear people say, I don't have those firearms anymore, I sold that firearm or it was stolen in the 1990s, so I shouldn't be in the automated firearm system. There's a form for that. Bureau of Firearms Form 4546. We have seen courtrooms that are including that form as part of their procedures. When someone says that, fill out the form. And that's in your materials as well, because that will help clean up the database and avoid unnecessary resources going to pursue people who no longer have the firearm. And you fill that out under penalty of perjury. Ghost guns, crime guns increasingly are unserialized firearms that are easy to get without a background check. So doesn't mean you can't get evidence about them. People are prohibited not only from having registered or legal firearms, but unregistered so-called ghost guns are prohibited as well. And they're not going to be getting those firearms back. So again, earlier in the process, obtaining those firearms can prevent unnecessary, riskier situations down the line. Getting that victor survivor input is critical. We know of a few cases where a victim survivor says, I don't want a restraining order. Law enforcement has pursued a gun violence restraining order anyway, and victims are incredibly afraid or put at risk or threatened. So taking a comprehensive approach and considering why a victim might be initially resistant and giving them some time to make a decision can make a lot of sense. And then how you manage these cases, ensuring that those who become prohibited are being managed effectively by their defense attorneys. Probation is as important as supporting those who need services in terms of increasing the possibility of safe outcomes. So let me stop sharing, and then I'm happy to answer questions. Who governs gun buybacks? Gun buyback programs where law enforcement or others offer, sometimes a nonprofit organization offer to pay people to turn in their firearms or firearm parts, are usually handled entirely by that entity that's putting them on. Last year, it just became effective January 1st of this year. So that's AB 2842. Came about because there's been concern that whoever's running the gun buyback works with a third party that hasn't always destroyed the firearms. There was an investigation by the New York Times that revealed that some of those folks were just reselling those firearms or selling the parts. So this requires that law enforcement entity or those doing gun buybacks are ensuring that they're working with folks who destroy the firearms instead of reselling the firearms. So if you're interested in that, you can take a look at AB 2842. There's a link to how to look up bills in that handout that's in your materials too. But they're governed by the law enforcement entity handling the gun buyback program, and then by state law on destruction and resale. Okay. Any other questions at this point? I know it's a ton of information. Really appreciate you taking the time.
Julia?
Yeah.
I have a question while some others are formulating their question. So I see the notice from the court telling people what to do when there is a restraining order, within 24 hours and within 48 hours. I also note that there are 29 law enforcement jurisdictions in our county. That seems a lot, right?
Mhm.
Is there any way for us to track and document how many people actually comply within 24 hours? And likewise, when they fail to provide the proof, I think you also touched on this. They are supposed to turn it in and the court is supposed to let us know, but is there also any way for us to track and document what is going on in terms of people filing the proof of relinquishment?
Right. So great question. The most we've been able to do really is, these files are not confidential, meaning that they're publicly accessible. It requires it's more a mechanics issue. That is, um, who's the researcher who's going to go in and do that? There's no automatic reporting where the court is going to be printing out on a weekly basis who became prohibited and how many complied after 24 hours or put the receipt in after 48 hours. So it would require setting up a research plan with the court to track some set number of cases um, to determine the time between prohibition and compliance. The alternative or a parallel effort would be to talk with the Department of Justice to see if they have any data that show in the county the date by which this information's there. It's just a matter of whether they can provide it on a sort of broad basis, that when the person became prohibited and when the prohibition was entered into the DOJ database, and whether they're also in the armed prohibited person system. So it's a long way of saying that the information's there. It's just not something where you can push a button and print that out. That's not posted information. So it would require a design for a research study, and then cooperation from the courts and DOJ.
Thank you for that. I have one more question. So I know that we have a lot of advocates today in this meeting because we've asked our advocacy partners also to attend to learn about this law. While the enforcement really falls heavily on our law enforcement partners, what do you think you would advise our advocacy partners, our domestic violence advocates and DA victim advocates about this area of law?
Sure. Well, one of the lists of components of how we know we're successful includes having a place for non-compliance to be reported. So, when the things have fallen through the cracks, I want advocates, providers to know how they can assist with quickly and most effectively addressing non-compliance. So if that procedure isn't there, I'd say let's work on that. How do they notify the DA? What is the value of a civil restraining order in Contra Costa County? Can you follow up with the district attorney or law enforcement through some kind of process to say, I'm concerned about this violation? And then is there a way for the court to be responsive as well? And then at the front end, I'd say just having the conversations about the availability of firearms, counteracting the notion that you're safer with a firearm than without in many instances. And I recognize that this is not an easy message to communicate. People have firearms for self-protection. Often when they feel that the law enforcement may not be responsive, some of them have firearms for those reasons. And they may themselves be victims. But having that conversation about safe storage, why it's important to store your gun responsibly, locked and unloaded, and to reduce risk of youth suicide, unintentional shootings, or having it be accessible to someone who's committing acts of domestic violence. So service providers are in an excellent position to have the conversations, expose people to public health information about risks, identify ways to safely store and include that in safety planning, and to be thinking about why a prohibition if voluntary separation from firearms isn't going to work, why a prohibition might work. And then if that prohibition's in place, does the county have a protocol for following up when there's non-compliance? That would be the whole framework. And I think service providers are essential to that.
Yeah, thank you so much, Julia. That was a great answer. And I also realized that there's more work to be done with our service providers, with your answer and also with your framework. So thank you for that. So I think Natalie, I don't see any other questions because I think you were so thorough and your presentation was really well organized. And Natalie, I think is gonna share information on what we have in place in Contra Costa County.
Yes,
Natalie?
I'm putting it into the chat right now. So this information is really for those both parties for domestic violence restraining orders where they can get more information. And it includes information about relinquishing a firearm and how to do that safely and the appropriate ways to follow the law.
So what I would say is that this website was developed a couple of years ago with another state grant, the Office of Emergency Services grant, Julia. And I think we would love to update this website if you could also have a look and give us some additional insight. But we try to make this accessible for people who are seeking restraining orders, as well as people against whom restraining orders have been issued. We try to make it as accessible as possible, but I think we definitely want to update this website. And also, we're going to have this information available in multiple other languages. Currently, it is available in Spanish. So it's for you to have a look to get information because there's a lot of information we shared today, but this is kind of one quick way to have some information.
Excellent. I'm happy to take a look. And kudos to you for putting it together and making it available. So thank you.
All right. So I think with that, thank you so much, Julia, for your expertise and excellent presentation. And thanks to all of you who stayed the whole 2 hours with us. Good for you. And in fact, I think we could give you 4 minutes back. How about that?
How about that? Well, thank you.